With, yep, I will redo that because my mic is not on. That's what I pressed. I'm calling this meeting to order of the Civil Rights Board, this special meeting on September 7th at 7:03. We will now move on to the roll call.
Thank you. Director Harrington. Director Beach.
Present.
Director Corwin.
Present.
Director Lukeman, sorry.
Present.
Director Calden.
Present.
Director Brown. And Commissioner Hoffman.
Present.
All right, thank you so much. May I please have a motion to adopt the agenda for today?
So moved. I second that.
All those in favor of adopting the agenda for today, please say aye.
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 Aye. Any opposed? All right, thank you. Now moving on to the approval of the minutes from our last meeting. May I please have a motion to approve the minutes from the last meeting?
I motion to approve the minutes from last meeting. I second that motion.
All those in favor of approving the minutes from the last meeting, please say aye.
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 Aye. Any opposed? Okay, thank you. Now we're going to move on to public announcements and communications.
Thank you, Director Harrington. I do have a communications, had the honor of introducing the new D&I coordinator for the city of Kalamazoo. She officially got started, I believe, yesterday at the City Commission meeting. Tanya Hewitt-Smith, and I'd like to maybe have her come up and just introduce herself, and she will officially take this role and this seat next month. Ms. Hewitt-Smith, please.
To introduce myself, my name is Tanya Hewitt-Smith. I've been with the City of Kalamazoo 29 years so far. I look forward to meeting with all of you. Today I am in the audience for observation purposes only. But beginning October, I'll be right up there with you. Thank you.
Thank you, Ms. Hewitt-Smith. And also, I am going to put her on the spot, but Tanessa, would you like to come over and just tell them the changes that's happening with you within the city?
I will be beginning soon. We're doing some transition. I am going to be moving to an executive assistant position in the city manager's office. So that will be coming down the pipeline. Currently, the new DE&I director is hiring for my current position. So that will be coming up soon. The posting actually closed, I think, last night. So that'll be happening soon. And then I will be assisting with the transition. So you're not quite rid of me yet, but super happy to be here and make this transition as smooth as possible. So if you need anything, reach out.
And thank you. That's all the communications I have.
Thank you so much and welcome. All right, moving on to new business. We are going to start with our hearing for today. If I can please have Commissioner Corwin take a step down. Okay. We have before us a complaint alleging a violation of Chapter 18A 2B of the Kalamazoo City Code of Ordinances. The complainant, Dustin Corwin, alleges respondent, Berkshire Hathaway am I reading the wrong one? Oh, that's the one that was up here. Hold on. This is the one that was sent us. Tanessa, do you have an updated one? Because this is the one that was sent. Okay. Got it. All right, we're going to pause for a moment. Got it. Okay, it's actually a typo. So, beginning again. We have before us a complaint alleging a violation of Chapter 18A 2B of the Kalamazoo City Code of Ordinances. The complainant, Dustin Corwin, alleges Candlewick Apartments property management violated Section 18A4 of the Kalamazoo City Ordinance by denying him housing based upon his past criminal convictions. I'm just gonna do this one. The complaint was investigated by the city attorney's office, and their findings and recommendations were provided to the complainant and the respondent. Respondent was found to be in violation of the ordinance. The city attorney's office recommended that a voluntary settlement agreement as provided in Ordinance 1810 be pursued with Candlewick Apartments that provides that Mr. Corwin be offered for a rental the next available apartment that meets his needs. The application fees paid by Mr. Corwin and Ms. Wells be refunded to them. The city is to be provided updated policies and applications that, to the city's satisfaction, clearly identify procedures that will comply with the requirements of 18A4. If a settlement agreement consistent with these terms is executed, then no further enforcement action is recommended. The board has had an opportunity to review the complaint and the investigation report. We will ask if the complainant has anything additional to say. We will ask if the respondent has anything to add. Directors may ask clarifying questions to either party. At the conclusion of the hearing, the board will make a recommendation to the city manager. The complainant is a current director on the board. We are committed to remaining impartial in this process. We note, for the record, the investigation was concluded before he became a member of the board. Mr. Corwin. We have had an opportunity to review your complaint and the investigative report. Is there anything further you would like us to know?
I'd like you guys to choose prosecution this time, simply for the fact that I attempted in every way, and I can go through this timeline of events to educate them on the policy, even going as far as printing off the law and hand delivering it to the manager. And at that point, she had told me that she couldn't have any more communications with me because then it might take it into a legal matter. So, like, I personally tried every approach that I found reasonable, even went over, over and over and over again. I first went there and I asked them personally, hey, do you guys allow felons to rent here? They said yes, as long as it's a low-level felony. I'm like, great, because I have a D2 lowest level felonies in Michigan. So there's no way that, given that definition, that would not meet that criteria. After, I'd say half an hour of talk, I felt confident that I could apply for this apartment. So I did, my girlfriend did, we both were charged $35. Then we went through a background check, and the background check automatically denied me. So it wasn't necessarily Candlewick. They had delegated their responsibilities to an outside contractor. The outside contractor is the one who told me no. And then the outside contractor didn't allow me to appeal it. I tried to appeal it, but the appeal process, I wish I could explain how, if something's so confusing, the average day citizen wouldn't be able to do it. And in this process, there was no appeal process for any of the conditions, and no others or anything. So at that point, I did cease this, and I tried to reach out to the parent company, to the delegated responsibilities to all those companies. I tried to notify management that under Ordinance 18, it says that, it doesn't matter who's involved in the process. This falls back to the one who's responsible for the process. So I'm asking that you guys, honor all the educational opportunities that I tried, and realize that, in no way, shape, or form was this anything but malicious. They knew what my intention was, just to advocate for my own rights. And once they knew I had the power of the law, at that point, they tried everything to shoo me away. And again, I didn't even get return phone calls. So about 2 weeks ago, I finally got an approval from this company. After over a full year, I haven't contacted them. So my best guess is something was coming up. And another guess would be this, I don't know. But something had them after a year, and then automatically just approved me without even contacting me, which I think is probably irresponsible on the company's part. I mean, at first they said I couldn't do that. You know, they gave me a full blanket policy. And by the end, I wasn't even given an opportunity to explain. I was just automatically accepted. So again, this isn't appropriate, and there's no reasonable reason for these actions. So I'd ask that you guys look at the work that I did and go to the next step. Education did not work, and when I advocated for my own rights, nobody cared. Thank you.
Thank you. Do we have any initial questions from the board for Mr. Corwin?
Mr. Corwin, were you placed on a waiting list for a unit?
No.
Did you or Ms. Wells reapply through Candlewick?
No, we ceased all contact once I realized the process was unachievable.
In the investigation report, it says that Ms. Wells has good credit. Was that something that she was made aware of from Candlewick?
She was denied due to my criminal background.
Okay. Had she had an approval on her own?
I'm not honestly quite sure. We got a denial that was automatically sent to both of us. I mean, it was personalized to her, but again, it was denied based on mine, from my understanding.
Okay. Thank you.
This is Director Harrington. About how long passed time-wise between your initial conversations with you being forthright about your background and the denial letter?
It took me about, I would say, around a week in order to get comfortable and through the process of applying. And then once the application was in, it was within about a week or so, I got a denial back, I think. It's been a long time, but it was about that timeline.
Okay, thank you. Are there any other questions for Mr. Corwin?
This is Director Beach. On your application, did you disclose the felony that was going to appear on the background check on the application?
Yeah, of course, I did that. And I also verbally communicated my felonies to the staff member because I'm pretty aware that these things hold a stigma, so I just want to be upfront with it.
So before you submitted and paid your application fee, verbally and in writing on the application?
Yes. So on my application, if they ask for a felony, I listed all felonies. So I have 2 felony convictions, and I would definitely have listed those. Per when I went in at the very beginning before I applied, I made sure I verbally confirmed my charges with a staff member that I had spoken to.
Any other questions?
This is Madison Lukeman. I believe when I was reviewing the rent grow denial report, it did reference credit history or lack of credit history. But again, that goes back to my question of, was who the credit history would be related to.
So I also had notified them that I had a co-signer who made around $100,000 a year that had open credit, and there's no reason that the credit report would have been due because they were willing to go on the lease with me. But they had told me that when I applied, that wasn't the moment to do that, and that would be added on later. And come to find out, from my understanding now, she should have been on there with me at the time, but she still would have been denied due to my criminal background. So I understand the credit report might have been on there, but I think that that's pretty shallow because of the fact that I had already worked that out. And I had already given that information as well. And when I was filling out the application with the secretary, I made sure I told her that, and she said, that's later on.
Was it disclosed a minimum credit requirement?
To be honest with you, I don't know. And like I said, the co-signer would have met and exceeded that requirement. So I really wouldn't have paid attention to those details.
This is Director Harrington. When you initially had the conversation and you were being forthright about your background, who was that with? Was that with a member of management or was that with a member of the leasing team?
So that was the secretary, I do believe. When you walk in, she handled all the application process with me. Later on in the process, I tried to go to management. I only talked to management, I think, possibly once or something. And that was when I had Ordinance 18A, and she told me that she would not talk to me anymore while this was in, I think litigation was the word she used. So most of my experience has been with the secretary.
This is Director Harrington again. I just want to make sure that I'm understanding. For clarification, the person that mentioned litigation and that's why they couldn't speak to you further about it, that was the manager or the secretary?
That was the manager, the actual manager of this property who has the back office and everything there, who did at the time. And I even told her, I think the people who are above you might want to know that there's somebody's civil right in jeopardy here, because if I was an owner of a company, I surely would want my employees to tell me. She told me she had no way to communicate with them. And I still to this day do not believe it, because if something went wrong, she's calling somebody above. So she told me there was no way possible she could contact the owners in Indianapolis. And then after that, I tried to connect with the owners in Indianapolis, but they never returned my phone calls after I left numerous messages and explained that I was trying to settle. I did not want to go the full complaint process. And I actually did mess up an email too in there. I might have put it in there as evidence, but I was trying to communicate when I heard I had an appointment with the management. I tried to send an email over to the city and say, hey, I have a meeting, I think it's being handled, I want to withdraw this, and I actually sent it to her, right? So by the time I got there, she'd already read that one, obviously. She knew I was trying to withdraw my complaint with here. So I was like, hey, I did send you that, and I'm sorry, but hey, at least you know that I'm serious. This is what I'm attempting to do, and I don't want to do this. I just simply want a place to live. And at that point, it was nothing.
Are there any other questions? Okay, thank you, Mr. Corwin.
Thank you.
Is there a representative for the respondent here today to speak? Right, hello?
Evening.
Evening.
My name is Brian Weiss. I'm the local counsel for Candlewick. They've asked me to appear at the meeting to discuss how they intend to and have gone about addressing some of the issues that were experienced by Mr. Corwin. I do appreciate the clarification on Mr. Corwin's status on the board. I was a little bit taken aback this morning when I looked at the website and saw that he was a member, so I do appreciate that. I initially want to note that I, unfortunately, can't really address a lot of the facts that Mr. Corwin raised. There has been a great deal of upheaval and turnover at Candlewick, particularly in the last year as far as management, addressing various issues unrelated to this ordinance, but there has been some significant management issues that they've had to deal with. The property is managed by an Indiana company, Ziden Management Group. And Candlewick is, frankly, one of the larger landlords in Kalamazoo. So certainly they have an interest in cooperating with the city and this board in trying to formulate policies that are in compliance with the ordinance. And one of the issues, and Mr. Corwin referenced this, so I think I want to, because I was going to talk about it anyway, but one of the issues that Candlewick has had to deal with, and many larger landlords are also having issues with, is they do use nationwide vendors to screen applicants and take the application fees. Candlewick now uses a company called Yardi. There is several reasons that these larger companies will use third-party vendors, and there's actually good reasons for that. And one of the reasons that they use those companies is because it eliminates any bias of local management. It allows objective consideration of applications. What the issue becomes when something is looked at objectively, it makes compliance with this ordinance more difficult because it does require some subjective review of certain factors. So there's multiple layers of trying to deal with that issue with these larger vendors. And I know there's multiple municipalities around the country of similar ordinances, and I'm understanding that Yardy has made some advances in dealing with that, although I can't speak for Yardy. But I have spoken with Candlewick's corporate counsel in Indianapolis, and she did indicate that to me, and she's in fact had multiple conversations with Yardy. What I'm told is that Yardy at the time, or Rent Grow, whoever was dealing with this at the time of Mr. Corwin's application, apparently was not aware of the city ordinance, which had been recently enacted. And I frankly think there were a lot of landlords who didn't have an understanding of the ordinance or what was required. I represent numerous landlords with properties in the city, and have had to do some education for many landlords over the course of the last year and a half or so. And it has created some issues with management trying to understand how to comply, what needs to be done, what policies need to be changed, et cetera. I will say also, based on what I'm told from upper level management at Ziden, is there are very few applications at Candlewick where denials are based on someone's criminal record. So it is not a pervasive issue. In my conversations with corporate counsel, and I did provide, I believe she spoke with Ms. Jones this morning, and did provide her with an email as well. They did indicate to me that they would like to resolve this matter. I was, I guess, a little taken aback by Mr. Corwin's comment about prosecution. I'm not 100% sure what that means, frankly. And I would hope that that's not something that is on the table. I don't know if that means criminal prosecution or what exactly prosecution would mean in this instance, but I certainly don't think that that is an appropriate initial step. And I would hope that that's not something that this board is going to be considering. I will say that we do need some guidance from the city as far as being able to review the recommendations, written recommendations that come out of this meeting. Candlewick did advise me that they are prepared to do the following. They will refund the application fees to Mr. Corwin and Ms. Wells, provided they are given information as to where that refund should be made, whether it be Mr. Corwin's personal address or in some other fashion. If Mr. Corwin and Ms. Wells are still interested in an apartment and they meet all the other requirements related to income, they would allow him to reapply without an application fee and would be able to rent, or would, if he does qualify, rent an apartment as long as there is availability. Candlewick has gone and updated some of their internal policies to reflect the ordinance, but corporate counsel did indicate to me that they would like input from the city as far as what is required or what they would like to see in a denial letter from the applicant. In reviewing the ordinance, I think landlords are having a hard time determining exactly what they're required to do, particularly, the language is somewhat vague as far as what that is to look like. And I think if there was even some proposed language that could be provided to the landlords as far as what that would look like, it would be helpful, so that we're not kind of hitting and missing as far as what the folks at the city would like Candlewick to do, or any landlord to do with respect to those denial letters. So I think it would be helpful to get some specific direction on some of this, as opposed to trying to review the ordinance and sort of kind of guess what should be or should not be included in those types of letters. We will need to, Candlewick will need to coordinate with Yardi to ensure compliance on that front, and once we have some guidance, that will be a step that upper level management will have to take with that third-party vendor. Candlewick, we also discussed, or I discussed with Candlewick, the possibility of amending its application regarding consideration of criminal convictions. Mr. Corwin is correct that there is a section on the application that asks about criminal convictions. What is not on the application is an opportunity for a prospective applicant to provide information up front regarding any mitigating factors, including documentation evidencing rehabilitation as defined in the ordinance. My recommendation to corporate counsel was that they consider putting in the application or allowing the tenant to specify any mitigating factors and provide that type of information as at the time of the initial application, as opposed to the landlord having to circle back and reach out for that information. Allow the tenant to provide that up front. And I think that would maybe go a long way toward getting a more subjective review from these third-party vendors, and that was my recommendation to hopefully try and avoid some of these issues in the future. Candlewick will agree to post the ordinance on its website or a link to the ordinance. I will say Candlewick does require all of their local management to go through fair housing training. If, however, the city has some type of ordinance-specific training that it feels would be beneficial, Candlewick would be willing to participate in that program. But they do fair housing training as a rule with all of their employees. That, however, would not include training related to this specific ordinance. At this point, if the city puts forth written recommendation, Candlewick will work to comply with those recommendations. And to be honest, the ordinance does present some challenges for larger landlords who screen multiple applications and use third-party vendors. It does present some challenges. And so we've got to work through those, but the goal is to, as one of the larger landlords in the city, to work toward compliance with the ordinance. So again, I wish I could provide a little bit more information on some of the facts regarding specific to Mr. Corwin's situation, but there is nobody that can do that because the people who dealt with Mr. Corwin are no longer with the company.
Okay, thank you. Do we have any questions from the board?
This is Commissioner Hoffman. I don't really have any questions, but I do have a few comments as it relates to this case. When I think about all of the work that went into getting this ordinance passed, all of the community outreach that was done, that can't be refuted. We had several meetings with organizers and property owners and landlords to talk about what we were trying to do. When I think about what has happened in this instance, it reminds me of desperate impact. And how do we mitigate that? We already know that individuals who have criminal backgrounds, hence the purpose of really expanding the housing equity ordinance to cover those, because our system is baked in inequities, and it also really does not give a leg up to those who are marginalized and who have barriers already because of our legal system. What landlords are required to do, I think in this instance, we would want owners to treat all individuals in the same manner in which they would treat their own family members who have had hiccups, who have made choices and or mistakes that were not for their highest good. Everyone deserves a place to live that's filled with dignity and respect. And to say that 2 weeks ago that they somehow were approved to move in is, in my opinion, is very disrespectful and dehumanizing, because they will always be looking at living in a place where they have to look over their shoulders. And so when we talk about retribution or how Candlewick should be penalized is not the wrong word, but how Candlewick should hold and sit with that responsibility, I think we as a board should take a look at that.
Thank you, Commissioner. Are there any other questions? Okay.
Mr. Weiss, thanks for showing up today. Appreciate it. It's nice to hear from Candlewick, and I think that you bring, and Candlewick brings to light some issues that, being a participant that I was in the drafting and the feedback that landlords were providing with the ordinance, I think that you touch on several items related to some of the vagueness that we're experiencing on a variety of levels with the ordinance, not just specific to criminal history. I can say that from what I recall when we were participating in feedback and drafting the ordinance, that the request from the group of landlords was more guidance on acceptable language for denial. What are the guidelines for denial? We were very keen on having boundaries and limits and very clear understanding, because myself as a housing provider and my company, we have spent thousands in legal fees trying to make sure that what we do is acceptable to the ordinance as well. And with that, I think that it's unfortunate to hear that, I'm a small landlord compared to Candlewick, but that Candlewick hadn't put the work in when the ordinance came out to make sure that their policies were lined up with what this ordinance says, whether it was turnover, whether it was not. Corporate does not have the turnover, but the smaller landlords are putting in the work to make the changes. So it's, and we don't have the backing or the funds that Candlewick might have as well. But I think what I appreciate is that you've come today with a plan and an execution, that they're responding and they want to cooperate. So thank you.
I can't say that I disagree, that they should have been more cognizant of the ordinance from the outset. And I can't necessarily explain why that was not the case, other than maybe a failure on my part to properly communicate the existence of the ordinance, but we'll save that for another day. So I will say in response to is it Director Hoffman?
Commissioner.
Okay. In response to Commissioner Hoffman, certainly I don't disagree with what you said. Candlewick does not disagree with what you've said. I know that there is a little bit, it's sometimes a little bit harder for larger landlords to wrap their arms around these things than it is for some of the smaller landlords. And when I say that, what I mean is there's folks making decisions who may live in Indiana that are trying to understand what's happening in Michigan or Ohio or Tennessee or wherever they might have apartment complexes. And so what I've heard from some of my larger landlords is, well, that's not the way it's done in Indiana. And, well, you're not in Indiana. And so I think that there's a recognition that there were some balls dropped in this case, and I think Candlewick has indicated to me that they are willing to make some changes. Interestingly, just as an aside, not specific to Candlewick, I will say, and I don't know if Ms. Lukman, how she looks at this issue. One of the things I've found when I reviewed the ordinance and have advised some of, particularly my local landlords, is in reference to the application fees. What I have told most of my local landlords, and most of them have complied, is simply eliminate them. I don't see any point in moving forward with application fees, given the amount that is being charged to some of these tenants to simply apply. I don't think that in some of the requirements, that if you do take an application fee or require an application fee, then to comply with some of the elements of the ordinance related to that. My advice to many landlords is just to eliminate application fees altogether. And that's the direction I think many of my clients have taken. But with some of these larger landlords, the application fees are primarily related to the third-party vendors, not necessarily to the local apartment complex. So there are some difficulties. I'm not going to sit here and tell you that mistakes weren't made, or that that management should have been more familiar with the ordinance, because they should have been. And whether that was my fault, I guess I'll fall on my sword, so to speak, if that was in fact where the blame lies. Although I think there just was frankly a disconnect, and part of that was local management, and part of it was just the size of the organization. So if nobody else has any questions, that's about all I have.
Thank you so much.
You're welcome.
Okay. I know we've had some preliminary discussion, but I'm going to formally open up for additional discussion amongst the board about thoughts, aha moments, questions for one another.
This is Director Beach, Attorney Weiss. I also would like to thank you for showing up. It is nice to be able to hear from both the complainant and the respondent. And also, I would like to thank for the accountability and the acknowledgement of that there were balls dropped, and there is turnover, and yes, there are all these excuses, but at the end of the day, our ordinance wasn't followed, and I think it's important that that is acknowledged and that accountability is addressed. I will say I do think there were some plans outlined of how there can be resolution and a agreement to address harm in the future, and I think refunding application fees is frankly, no-brainer. I also will say I am, frankly, again, the recommendations we are receiving as a board are disappointing from the city attorney's office. Again, we have recommendations with no timelines, with really no meat, no teeth, nothing, frankly, copy and pasted. So I hope to see a little more intentionality given to future recommendations following the time and feedback, and now hearing the discussions we're having. I also want to highlight, we have had a lot of confusion and lack of clarity amongst us up on our board, and I think the request from our landlords to get some clearer guidance from the city if they are asking for if they are asking for feedback of how do we create local policies, or how do we that is fair feedback that we need to hear, and we need to I like the plan to work through to come to a resolution. We need all of our landlords we need our landlords as a partner, but we also need to make sure that everyone's civil rights and basic civil rights are followed and are recognized as the city of, as we as the city of Kalamazoo has determined is important to us. So I would, my recommendation would be to amend, or my initial thoughts are to amend the city's recommendation to the city manager's office to add some of the things that were that we've discussed. But those are just my thoughts. I would be open to hearing other ones.
This is Director Harrington. I share Director Beach's concern that after an extremely lengthy discussion at the last meeting following the first hearing, that was not included in the recommendations that we were sent. Because we obviously spoke last meeting about wanting clear guidelines, something that would be easy to communicate to respondents, because our goal is to actually make an impact with this ordinance. That's the whole point of us doing these hearings. I don't think any of us sitting up here because it's fun on a Wednesday or Tuesday night. We're actually doing this work because there was so much work that went into the ordinance in the first place. But none of that matters if we can't do something with it. And that involves having clear direction to not only the people in the city that are looking for housing, but also to the housing providers. If we actually want impact, we have to be clear. And as Director Beach said, intentional. And that was brought up today by someone who represents multiple landlords in Kalamazoo. Absolutely, absolutely. As someone who is a housing provider myself, I understand the time and energy that goes into being intentional. But isn't that the point of the word? You're not speeding through things and disregarding, in this case, humans, but you are stopping and taking a moment to make sure that you're doing the right thing. Yes, that's going to take time. It's going to cost money. But that's the whole point of why this ordinance was passed. So we as a board have to be mindful that we are in partnership with housing providers. We do have to go over and above so that there is no excuse as to why someone doesn't understand the ordinance. I view that as our job. We have to make it plain, simple, and easy so that if you are in violation, there's no excuse. It is plain and simple. And when we have hearings, it is plain and simple because we know that we did our job and our due diligence to make sure that there was no confusion. There is confusion right now. This is why I have spoken before about how important education is. And I'm really looking forward to spending the next several months of this year organizing around that. Our goal should be to not have any hearings. That should be our goal as a board, that hearings aren't necessary. So I appreciate what was said today from the representation of Candlewick about what they are willing to do. One of the suggestions is actually what we spoke about last meeting in regards to training and what needs to be involved in that training, and that we be the ones to provide that training. We had already talked about that. And so I am inclined to take some of the suggestions that were already given to us from Candlewick themselves, saying this is what we are open and willing to do. And I'll leave that there for the moment. Any other questions or comments? If not, I think that we should have a formal recommendation provided that the board can decide on.
So I am going to, this is Director Beach, the initial drafts in terms of the recommendations I would like to see presented to the city manager's office, and I please encourage any of my other directors or commissioners to make sure I didn't miss anything that was discussed, is the application fees of Mr. Corwin and Ms. Wells be refunded. An updated application to be implemented to allow for additional comments and attachments to provide proof of rehabilitation or other factors for consideration for future applicants. An updated policy of how all local Kalamazoo ordinances will be processed in partnership with their third-party provider. I do hear the real reasons third-party providers exist, but I do think if you are doing business in the city of Kalamazoo, you need to have an ordinance, you need to have policies to how to address that. As well as local ordinance, as well as all of our local ordinance posted on their website, as well in all of their leasing offices. Those are the recommendations I would like to see, and I believe completed in the next 90 days to be submitted to the city.
Any other comments or additions to what has just been formally recommended?
This is Director Calderon, so I just because you said if you missed anything, to bring it up, we did discuss the training and who that would be provided for, or I'm sorry, who that would be provided by. And I don't know if I heard you say that. I'm sorry if I missed it.
I did not say that. I think the training is an aspect we need, but I think that is a training that we need to develop. So I don't know if we can put that in a recommendation while it's not developed yet. I am open to other thoughts though, because we don't have someone to provide the training that we would be asking them to complete at this point.
This is Director Harrington. Well, I do agree with that because we're putting a time stamp up on it of 90 days. I will say that we can amend it for that specific portion. So 90 days for the other things, and then maybe just leave a time or TBD. I don't know if that's even legally appropriate, but
Attend local ordinance training when offered.
yes, absolutely. Do we feel better about that?
This is Director Calderon-Wistow. It makes sense, but I do definitely appreciate the point that you're making about attaching an obligation to something that doesn't exist yet. So thank you for making that point.
This is Director Harrington. I'm just speaking so affirmatively because we are going to do it. So it's a duh, it's an official, we're going to do it. It's just not, it's in process. Let's just say that, okay? All right. So with that amendment, do we have any other questions, suggestions, or clarifications for the official motion or official recommendation, excuse me?
I have one addition. I think we should put a time on refunding the application fees. Just with a larger corporation, it can take a little while. So I think we need to anchor when the app fees should be refunded. And I would think 10 business days would be appropriate.
I think that's doable.
This is Director Harrington. Are there any other additions, questions, clarifications for this recommendation?
This is Commissioner Hoffman, and I can appreciate everything that's been said on the dais, and I would be remiss if I did not speak on behalf of the complainant in saying I can't imagine the mental anguish and pain that he and his significant other went through going through this process after revealing that there was a criminal background history. That is not easy to do. And so when I think of that, more needs to be done to acknowledge that and to pay homage to him and his partner, and also to set a precedent to other property owners and landlords that we do not take this lightly. One thing that I am pushing for is that the Civil Rights Board will have sole discretion to make a final decision, and that it does not have to go to the city manager's office for approval or disapproval. I believe when we did this for the last over 3 years now, it's been, we believed doing this work that the board would have that level of authority to make sure that nothing could come in and sway what we felt was right for our community members and our residents of this city. And so I just want to put that on the record. The mental pain and anguish, like that's heavy, having to disclose your life to people ongoing. Who wants to do that? But yet they had the courage to, and then was yet denied, even having an ordinance in place. So I can't sit back and say that $70 is going your way, thank you. And if you choose to live here, we'll have an apartment for you. That does not sit well with me, so.
This is Director Beach. Thank you, Commissioner Hoffman. And again, Mr. Corwin, thank you for, again, going through this very public process and sharing your process again. I echo your sentiments. Commissioner Hoffman, I think we have learned, and we're going to discuss again, and I think it's going to be a standing agenda item, that there are gaps in this ordinance and what are our abilities as a board to do at this time. But I do think it's important to acknowledge, and I am optimistic that we do have landlords who are showing up and taking this seriously and going through the process, and I hope to see the commitment and to continue to see the work and continue to see change in our community, because change is one step at a time. But I do want to, I'm going to read through what our final recommendations are, and so to make sure we're all on the same page. So first, the application fees for the complainants be refunded within 10 business days. An updated application to allow for additional information, supporting documentation, and other factors for consideration for application based on criminal record, credit, and the areas in the ordinance. An updated policy of how all City of Kalamazoo local applications will be handled and processed in partnership with any third-party vendors in relation to the ordinance. And then the ordinance 18 and 18A be posted on their leasing website, as well as in leasing offices within the next 90 days for those following three. And then to send staff to local ordinance training when offered by the city.
Sure, yes.
It's coming to Candlewick?
Yes.
Okay.
Yes.
And when we're talking about 10 days, it's not 10 days from today?
No, it's when you get those written recommendations from the city manager.
Okay, okay, thank you.
Yes.
Okay.
I have a point of clarification. The investigative report, along with the recommendations, were made several months ago. I heard the board clearly about providing additional deadlines and dates, and that will be in future reports. But this report, as well as the previous report, were prepared months ago.
Thank you for that point of clarification.
Okay. We're going to move on to the next item in the agenda. Are we voting on it?
I think, do we have to do anything to formally conclude the hearing? Okay. Vote, we have to vote.
That's fair.
So that is my motion.
That was the motion.
That was the motion. We need a second.
Thank you. May I have a second, please?
I will second.
Okay, all of those in favor of adopting the recommendations that were proposed, please say aye.
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 Any opposed? Any abstentions? Okay, motion passed with those recommendations. Thank you. Thank you, Tanessa.
Director Corwin, if you'll join us back up here.
Thank you. Okay, moving on to the next item in the agenda, ordinance revision update.
Thank you. The board had requested that our office revise and amend the ordinance to include language related to the vouchers. That has been done, and that will be sent to each of you this week for your consideration.
Thank you.
Are there any questions about that? Comments? Thank you so much. Moving on to board member application interview process update.
We have, the nominating committee has reviewed applications and completed interviews, and I am excited to share that we are recommending Lionel Legrone II for recommendation to the City Commission's office, Board of City Commissioners for approval to appointment to the Civil Rights Board. I am going to turn over to Director Lukeman to speak a little bit about Mr. Legrone.
I just want to first acknowledge the 3 applications that we did have, and we did interview all 3 of those applications. So I want to thank those community members that did apply. Mr. Legrone is the Managing Director of Social Impact at the Social Impact Policy Institute. He has 20 years of experience in public policy and civic engagement. Another reason for our recommendation was that he had spearheaded the creation and the community engagement of the Grand Rapids Human Rights Ordinance. It was a pleasure to interview him, and all of his knowledge that he can bring to this board, I think will be incredibly beneficial to the direction that we're trying to head in as well.
So I am asking for approval from this board to recommend Mr. Legrone to the city commissioners.
May I have a second?
I second that.
All those in favor of this recommendation, say aye.
Aye.
Any opposed? Any abstentions? Okay, thank you so much to our, nominating committee for bringing a great applicant to the forefront. We appreciate your work. All right, education update and discussion. So I kind of already touched on it in my remarks when we were having the hearing, but I would like to just lift up again the importance of this board making education a priority. I'm looking forward to the addition of our new board member. And I guess I can publicly say I will be promptly asking him to sit on the education committee. So once that is official, I would like to start convening education committee, subcommittee meetings so that we can really get the ball rolling on making sure that community members and housing providers are receiving the education that they need in order for this ordinance to be successful. So I just wanted to give that update, and I was wondering if you all had any updates at all. No, okay, awesome.
And the Education Committee will be working with the City Attorney's Office to develop that training that we have discussed that is needed for our local ordinance. Once we once we have a full committee, I also would like to lift up the request that was made by our landlords and the guidance, and I think that charge of if there are things that resources we can start to develop and provide in collaboration is something I think that group is the next step as well, engaging all levels of our community to make sure this ordinance can actually work and is working how we intend it to work.
Okay. Moving on to citizen comments.
We're checking now.
We have one caller. Caller ending in 0411, you're with the board.
This is Richard Stewart. I am a citizen of Kalamazoo in the Southtown neighborhood. Just a reminder, the board last year spoke on more than one occasion about the name of the board being Civil Rights Board, that there was some concern in the public that it is a dishonest name. You do not indeed represent civil rights of all people. You have a very distinct authority. It has nothing to do with civil rights that I have. And it is misleading, creating confusion in the public. They are referring complaints to you that you do not hear, acting as the city, as the middleman to complaints that go to the state Civil Rights Board and the Department of Justice, specifically in disability, that you continue to flaunt your nose at, as you do not represent disability, and this board does not even take the recommendations on operating the meeting in a form that is friendly to all, including neurodiversity. I would just like to remind you that we have had this discussion, and I keep it at the forefront, and I am shocked that you do not keep it a priority of naming this board accurately and stop deceiving the public and yourselves with this false name. Also, Director Beach, I have been trying to get a message to you to invite you to speak at the KREA Landlord Housing Provider Group so that you can educate the largest group of housing providers in this area so there can be no further misunderstandings like the unfortunate event today with Candlewick. Thank you.
Are there any more citizen comments?
It does not look like so.
Okay, miscellaneous comments by the board.
This is Director Beach. I just wanted to take a moment to thank Director Green for his time as interim DEI director and for his work during this transition. I also would like to take a moment to thank Tanessa Patterson for all of the work she has done for us over the past 2 years now. 2 years now, assisting a brand new board. As we have learned through this process, I will be the first to recognize has not probably been easy, and your work has been recognized, and you have made a difference to the work we do and made our work easier. So thank you for your service, and I'm excited to see what you do next, and thank you.
Any other board comments?
This is Commissioner Hoffman. I just want to end my comments with, in 1948, the United Nations declared housing a human right, not circumstantial, but a human right, such as having access to water, food, and anything that sustains human beings on the earth. And so this work of the board is, however, it is not perfect yet. We are working towards something that is going to impact and change the lives of many. This is the first ordinance that this community has ever had in its likeness. And so, of course, there's going to be some tweaking that needs to be done, and we will not please everyone all the time. I would encourage us to all be vigilant and to stay steadfast and knowing that humanity has to be priority number one.
Thank you, Commissioner. Any other comments? Okay, well, I would also like to thank Tanessa for your grace and your patience with, as Director Beach said, a brand new board, learning and growing, and not answering your emails right away. So you're a saint just for that. For staying on top of me personally so that I can answer my emails. So I just want to say that I know that you are a talent with your profession, but also just invaluable as a person. And wherever you go, you're going to have so much success. So thank you so much for everything that you have done for this board. We really appreciate it. And the same to you, Director Green, because we have appreciated you during this transition. You have also been wonderful and just jumped in with 2 feet. So we have appreciated you. Thank you so much. All right. With that, I'm going to adjourn this special meeting at 8:12 p.m.